Welcome to Today with Dr. Kaye. I'm Dr. Kaye Whitehead. I'm joined now by Jonathan Schochor, the founding partner and chairman of Schochor and Staton. He and his firm have recovered well over $1 billion on behalf of his clients and have prepared and filed more medical malpractice cases than any other lawyer or law firm in Maryland. Attorney Schochor was the chairman of the steering committee in the levy class action against Johns Hopkins Hospital. And in 2022, he was in the edition of the best lawyers in America for medical malpractice law, plaintiffs, and mass tort litigation class action, as well as a long list of national, lifetime, and local awards. Attorney Schochor, thank you so much for joining us today.
It's a pleasure. Thank you for having me.
Absolutely. I want to start by asking you to talk a bit about Maryland's new law that will eliminate the statute of limitations and allow victims' cases to be heard in court. This is unprecedented.
It is in Maryland. Other states have done it. It is a huge victory for victims of sexual abuse in Maryland. The law lifts the statute of limitations so that victims of sexual abuse can come forward, enforce their rights in a civil litigation setting, and obtain full, fair, and adequate compensation for the tragic circumstances involved.
Now, the statute, just so that I'm clear, is not only pertaining to victims who have been sexually assaulted and abused by the clergy, but it also opens it up for teachers, coaches. Can you talk a little bit about that and why this is important, of course?
It's extremely important, and you're absolutely correct. The new law lifts the statute of limitations not only for clergy and allied professionals in the clergy, the archdiocese, but in addition to that, and there's been some confusion on the part of the victims here and the general public, it lifts the statute of limitations for any and all sexual abusers in Maryland. So that if, hypothetically, or for example, a coach is a sexual abuser, or a scout leader, or a prison guard, or a teacher, victims of sexual abuse may come forward, file suit, move forward in a civil litigation setting, and prevail.
Now, given the fact that when we saw the number, when the report came out of more than 600 victims spanning over 8 decades, it was overwhelming. And with that in mind, what are some of the support systems in place? Suggest that you can have a civil case, or there are other things that you're going to be able to do to help the survivor victims?
Well, first of all, they indicate, meaning in the Archdiocese report, that there are approximately 600 victims. I've been practicing law for approximately half a century, 50 years. Most of that, almost all of that, in Maryland. In my professional opinion, there are thousands of victims. And we all know, as professionals, that obtaining appropriate compensation for victims will put in place many support systems that otherwise these victims would not have access to. For example, counseling, psychiatric, psychological counseling, other programs to help victims move forward, obtain closure, obtain more mental stability, and importantly, hold those accountable, which is important in our society, hold those accountable for what they did.
I know that sometimes it is difficult in cases like this when people come forward with their stories, with this idea starting at the place where we believe those who said they have been victimized, and that the burden of proof to claim that it didn't happen falls upon the church or the teacher or the coach. In this particular instance, does it start with that? Do we start with the idea that we're believing people when they tell their stories?
Yes, for example, I was the chairman of the steering committee, as you alluded to, in the Hopkins litigation, where an OBGYN took unauthorized photos, videos of female genitalia, if you will, and also was guilty of other boundary violations. I had the honor, actually, of representing approximately 8,000 women who came forward. At first, they were reluctant. They were reticent to come forward. A lot of them were severely emotionally unstable. But when we were able to interview thousands of them, and our firm, Schochor and Staton, did so, and explain to them that we will take them by the hand. We will walk them through this process. We will protect their anonymity to the fullest extent of the law, should they want that. That there's no financial obligation to come forward. They don't have to pay anything to be represented. They only have to pay a legal fee if we're successful for them. And that any and all consultations with us are wholly confidential. Once that information was received by the victims, their reluctance disappeared. They came forward, they joined our team. And as you know, we were able to achieve a $190 million settlement on behalf of these 8,000 clients that we represented, which was reported to be the largest single sexual abuse settlement in the nation's history at that time, and remains the highest, largest sexual abuse settlement in Maryland history. Therefore, we consider ourselves, and others consider us, as recognized leaders in this area. And we are ready to move forward. I've done it before. I'll do it again.
Now, I know that no amount of money is enough for what survivor victims have endured. But can you talk a little bit about the monetary cap that's been put in place?
Certainly. Let me start by explaining to your listeners that we've had caps in Maryland for many, many, many years. It's nothing new here. For example, there is a cap for medical malpractice cases, and there's a separate cap for general negligence cases in Maryland. There's a cap for governmental cases against the government, and there are caps in this litigation, in this legislation as well. The cap for governmental is $890,000. The cap for non-governmental is $1.5 million per claim, plus economic loss. So we're used to this.
Now, what advice would you give to a survivor victim as they are preparing for this process? Because it's not going to happen overnight. They're not going to come tell you their story and immediately get settled. Can you talk a little bit about that preparation process if people are thinking about coming forward?
Certainly. They would contact Schochor and Staton. We would have our lawyers and myself, I'm actively involved here, interview them confidentially, understand their story, gather the necessary facts with which to proceed, take them by the hand, as I already said, guide them through the process, protect them with their anonymity if they so desire, communicate with them once a month to give them status updates on the litigation, and move forward in that way. They would be protected by us and sheltered by us through this process, which can take time. There's no question about it.
I was wondering if there are family members where they know this type of abuse has happened, but the survivor victim has chosen to take their own life, that it was just a little bit too overwhelming. Can the family come forward on their behalf, or is it just for people who are okay?
If the victim is deceased, the answer is no.
Okay. Now, what about for people who've moved out of Maryland? So if they've moved
Not a problem.
from it, well, they can still be okay. Can you talk a little bit
Certainly.
about my last couple of questions, just so people they can really understand kind of the burden of proof for a civil versus a criminal litigation?
Certainly, it's a great question. The burden of proof in civil litigation is dramatically different than the burden of proof in criminal prosecution. In a criminal case, it's clear and convincing evidence. It's beyond a reasonable doubt. You must prove the case in the criminal activity beyond a reasonable doubt. That's what the jury considers. In civil litigation, it is not that. We only have to prove our case on behalf of our victims and our clients beyond by a preponderance of the evidence. By a preponderance of the evidence, not beyond reasonable doubt. An analogy for that: most people think that if take a football analogy, for example, most people think you'd have to take the football and put it in the end zone in order to prevail. In civil litigation, all you have to do is cross the 50-yard line.
Okay.
That's a preponderance of the evidence based on probability. That's what we have to prove.
And then my last two questions for you. The first one is you mentioned earlier that even though the report says 600, with your experience with 50 years of being in the practice, that there are probably
Yes.
thousands of people out there. Is this a step towards trying to get more people to come forward?
Yes. I think that it's of utmost importance that the victims who are suffering in the state of Maryland and those who've moved out of the state of Maryland who want to contact us, that's perfectly fine. They should. I think that this legislation and the attention that has been paid to this legislation, because it's monumental for the victims, will convince people to contact us so that we can explain the process. And as I've already indicated, shelter them, take them by the hand, and move through this process together with us protecting them.
And then my last question to you, Attorney Schochor, thank you so much for joining us. In
Pleasure.
January of 2017, the Office of the Attorney General issued a report on untested sexual assault evidence kits in Maryland. What is the rape kit policy?
Well, these, under the circumstances of this legislation, there really isn't any, because this sexual abuse goes back 80 years. So rape kits are not going to be helpful unless it happened contemporaneously and was reported. And as you well know, and as your listeners well know, very few cases are reported. Department of Justice came out with some statistics, something like 29 to 33% are reported, the rest are not. And for many of the victims here that we're talking about today who need to come forward and call us, it was not reported. They may have told their family members, they may have gone to the church instead of the authorities. That doesn't matter now. They can come and call Schochor and Staton, sit down with us, we'll gather the necessary facts, and we'll prove their case for them. And there's a lot of credibility involved here. And as you well know, in my professional opinion, the defendants in this case do not have any credibility. That's my opinion, based on that report and what it says.
Thank you so much. Attorney Jonathan Schochor is the founding partner and chairman of Schochor and Staton. He and his firm have recovered well over $1 billion on behalf of his clients and prepared and filed more medical malpractice cases than any other lawyer or law firm in Maryland. Thank you so much for joining us, Attorney Schochor, and thank you for the work you're doing on behalf of the survivor victims that are out there.
Thank you for having me. It was a pleasure. If you need to follow up, I am available, because we're going to be moving through this together, and we need the media assistance to get the word out to the victims so they can get help.
And we're doing everything we can. Thank you, sir.
Thank you.